its intensity may be more than some wish to be exposed to. And those people should die.
So the SEC didn't come out and so much as announce that it was going to get into the ICO regulation game, but by their actions it appears that they are, and they're well within their rights to do. Like, what people don't understand with any sort of government regulator, whether it's the SEC, CFTC, or even FCC, they have broad investigatory powers, including broad subpoena powers, right? And a subpoena is just a request for documentation, request for someone to appear and testify under oath regarding these sales. And it doesn't strike me as surprising that the SEC has taken action to sort of not so much investigate, but probably try to understand what a lot of these ICOs are doing, right? And it's not uncommon as a securities practitioner for companies, especially if they're in like new technologies or suspect areas, to get a call, right, or get a subpoena from a regulator, whatever that regulator may be. Like, for instance, I've represented many cannabis-related ventures in the securities world, and it was pretty common, just by virtue of the fact that cannabis is still illegal at the federal level, but legal on a medicinal or just on a certain state level, for federal regulators to be interested. So it doesn't come as a surprise. You see a lot of money going to these ICOs, and I think a lot of it is a fact-finding mission, right? Which is fair, and that's their job. That's the regulator's job. So, but I say this: like, there's three tenets to sort of responding to these things. One, to be contacted by SEC, CFTC, it's not tantamount to culpability or liability, right? Like, in many, many cases, these are truly sort of fact-finding missions, right? Where it's not predicated upon any direct evidence or any direct facts that would lead to the imposition of liability, but rather there's some construct in the broad police powers that these regulators have, where they have a right to sort of reach out to you. And again, it's all voluntary until you receive a subpoena. When you receive a subpoena, then you obviously have to reply. But to cooperate and, when you have nothing to hide, is certainly in your best interest to do, because the inquiry does not necessarily mean that you've done something improperly. The second point, to my first point is, ICOs, right, to date, ICOs have not been outlawed in the United States. There's been very, very, very little by way of tangible law or substantive law decisions that relate to the function, the application of securities laws on ICOs, right? And, I go back to the Howey test, and there's a lot of discussion about the Howey test. The Howey test was decided in 1946 or 47, long time ago, long time ago. And there's a whole lineage of cases that sort of amend and reimagine Howey, right? So it doesn't, the decision on whether or not a token sale, is in fact a securities offering, it's not rooted only in Howey. There's quite a large amount of detail, in the lexicon that sort of changes that, right? And to the extent that regulators want to rely on Howey, well, I encourage issuers of ICOs to rely on Howey, right? And that's where I come up with this licensure model, which I've talked about before, and how the exception to the Howey test sort of fits in there. So, I would say, one, being contacted, receiving a subpoena isn't necessarily an indication of any sort of allegations of wrongdoing. Two, your position within the legal construct of the Securities Act and the Exchange Act is strong, right? So my first thought is, if you're going to go through an ICO process and you do receive a call from a regulator, my first gut isn't, well, we're going to come off our business plan, right? Like, that's not what crypto's all about. That's not what ICOs are all about. And from a legal perspective, it's a very passable, plausible argument to suggest that these utility tokens, when they're truly utility tokens, and you can't just call it a utility token, but if it is a utility token, then it must be something else, right? Absent an extrapolation of current law, right? And like anything, right? Any type of law, civil, regulatory, criminal, whatever, the first the first element, right, to prove those cases is intent. So the question becomes, did you intend or did you knowingly sell a security without a valid exemption from registration? And the question, becomes, well, based on, your reading of Howey and its progeny, did you in fact do that, right? And that's like your first base analysis. So I don't think, increased regulation should at this time warrant anybody planning an ICO to say, we're not going to do it, because inherently the law is there, right? Now the law may change, and it may need to change, right? You can't operate in a void. Crypto can't operate in a void. As much as like the anarchist element of crypto one, it can't operate in a void. Like somebody, CFTC, SEC, has to take control and has to define it as something and regulate it. That has to happen. Like as much as it'd be cool that it's just nothing forever, it can't be that. Or there has to be some special law, like with the FCC or somebody comes in and just dictates something. It has to happen. But right until that happens, right, you have to be part of the discussion. The people who are doing the ICOs, people working in crypto, have to be part of the discussion in terms of how do we define these assets going forward, right? So I say this: what's happened so far isn't enough to say let's abandon all ICOs. Be part of the discussion, right? Be part of crafting, the argument of what this is, right? Like help entrepreneurs and people who believe in the underlying technology of blockchain, and go from there, right? But be part of the discussion. Don't just sort of walk away because you think, well, we can't, it's legally indefensible. But it's because that's not the case. That's not the case. And three, finally, look, as with anything, everything is fraught with risk, right? But at the end of the day, you can only sort of rely on what's there, right? You can only rely on previous law and your own stuff. So just do it the right way, right? Do it the right way. If you have a security, then you have to treat it like a security, and one of the biggest problems with this is the SAFT agreement, right? You can't treat something like a security through the SAFT, the Simple Agreement for Future Token, and then later call it something else. Like, you're committed to that, right? I think that's a real problem, and I think that's where there's this disconnect. People want to use the SAFT, but then they want to come and say this is a utility token and not a security. And from a legal perspective, this just doesn't jive, right? So, it's an imperfect space. It's an exceedingly gray area, like Fletch. How gray? Well, it's like charcoal, right? But in the absence of clear guidance, I think those are the 3 points I would focus on and I would hit. And you've got to retain counsel. You've got to retain smart people who have securities backgrounds, cryptocurrency backgrounds, understand the technology, understand a little bit about payments, understand a little bit about commodities, and work with them and try to craft and try to understand what it is your token represents and how that applies to current law, because the current law isn't updated, right? So it takes this degree of interpretation. But if you spend the time, you do it wisely, and you say as you will do, then I think you put yourself in the best position for success and to avoid what's ultimately going to be sort of a regulatory onslaught, right? And I think that regulatory onslaught makes a degree of sense. I just think you have to be prepared for it and do it the right way, because it's going to separate the wheat from the chaff, the people who do it right from the people who do it wrong. So if you have any questions, feel free to hit me up, at@tracyfirm.com. I will talk to you later.
This is just one of many reasons why it would not be safe to use nitrate film in a portable projector.